Good evening, ladies and gentlemen, and welcome to the Royal Society of Edinburgh. Can I introduce myself very briefly? I'm John Arbuthnot, the current president of the Society, and very delighted to see so many people here tonight for the first of the series of debates which we're sponsoring here at the Royal Society of Edinburgh in partnership with the British Academy over the next year. And the aim is to enlighten the constitutional debate ahead of the referendum on Scotland's future relationship with the United Kingdom. We could easily have filled this society twice over. This is full and there is an overflow of 60 people, and we could have had twice as many people here this evening, and we may have to think about another venue which accommodates the number of people who want to come in the future. Anyway, you all know what's going to happen in 2014, and I regard this, as most people do, as the issue of Scottish independence is the biggest constitutional issue facing the UK at the moment, and indeed for probably as long as we can remember, with very far-reaching consequences for the UK as a whole. Before I say more about the evening and the series, I need to just cover some housekeeping aspects, which is, first of all, that in the event of an emergency, we will be told there will be an alarm, and we exit this room from the back. And the mustering point, very high-quality mustering point, is the George Hotel. And the bar can accommodate just about as many people as we got. Secondly, if you have mobile phones, please switch them to silent or preferably off, because they do affect the recording and the quality of the sound. And the third thing, which is quite important, this, like all the events that we run in the Royal Society, all such discussions and debates, is an open event, and we do record the event and we do film the event. And we put the edited summary of the event onto the website very quickly. So that is what's going to happen. The whole series will be published at the end, but we want to get the general issues raised by the speakers and the issues raised in the questioning for a wider audience, because there is intense interest among the fellowship on these matters. So the way in which this is being done is that over the piece there will be 10 of these events over 18 months. 7 will be held in Scotland, and 3 will be held in London at the British Academy. And the events are, if you haven't seen the programme, Scotland and the EU, which is the first event this evening. Defence is the second one, with international relations added to it. The real economy is the third. Culture and broadcasting is the fourth, which interestingly we've been invited to hold at the Parliament, which is interesting. The next one is borders, immigration and citizenship. Science and higher education follows that. Public services and welfare, which will actually be held in Glasgow and chaired by Robert Black and myself. Tax and spending, monetary policy, and we'll close with historical, legal and constitutional issues. And as I've said, in each case we will be collecting the feedback from these discussions together with the papers from the contributors, and that will then form the nature of a publication. I feel as president that this being such an important historical event, that we have two obligations. One is to stimulate the debate, because we have within the fellowship such a range of expertise that we can do that, and we have an obligation to do that. But the second obligation is that it is very important that somewhere there is an archive of more or less everything that has happened in these 2 years, and we are preparing such an archive, which we will hopefully document with the National Library. I think that is more or less everything, except, as you know, this evening is the focus on Scotland and the European Union. And that has been, like all of these issues, very currently important both in the press and in other venues, and particularly exercised over the last 6 months. The whole of this evening's event will be chaired by Peter Jones, who will introduce the speakers. He is a distinguished freelance journalist with The Economist, The Times, and The Scotsman. And we're grateful to Peter and our speakers in finding the time to do this, because it is a not insignificant task. So when this evening is over, and I think I have to decide when that is, then Michael will seamlessly come to this podium and thank folk and send us on our way. So over to you, Peter. Thank you.
Because we're a bit late starting, I'm going to be very brief with the introductions to the speakers. We have with us this evening, sitting in the middle, Neil Walker, who is Regius Professor of Public Law and the Law of Nature and Nations at the University of Edinburgh. He's an expert in European law, constitutional law, and constitutional theory in the Scottish, UK, and European contexts. At the far end, we have Diana Pankey, who's Professor of Governance in Multi-Level Systems at Albert Ludwig University, Freiburg. That means, I think, she's an expert in government at various levels, devolved, national, and local. And she's been previously an Associate Professor at University College Dublin. And then sitting next to me is Graham Avery, who's a senior member of St Antony's College, Oxford University, and a senior advisor at the European Policy Centre, Brussels. Graham has had experience of 33 years working in the European Commission, including in the Directorate for Enlargement Policy, which is, I imagine, where most of his expertise as regards this evening comes from. Ladies and gentlemen, would you please welcome your panel and the first speaker, Neil Walker.
Okay, thank you very much for the invitation. I will speak for about 15 minutes. I want to address 2 or 3 specific questions. One is what I would call the false legal certainty in the debate over Scotland's the accession of an independent Scotland to the EU. The second follows from that. It has to do with the fact that if the legal certainty is false, then Scotland's joining is very much more a question of politics, the dynamics of the political situation at the time. And the third point I want to make is I want to say something specifically about these dynamics in the context of Scotland's particular position as a small nation seceding from a larger nation. So let me start with the question of false legal certainty. As you know, on both sides of the debate, there has been a sense of certainty, less so now, but in the past, at the beginning of the debate, the position of the SNP and the independence movement was that Scotland would automatically become a member of the EU in the event of independence. There might be certain details to tie down, but there would be no significant legal impediment. And the British governmental view from the outset was very, very different, that Scotland would be a new state. It would not have an automatic seat at the table. It would have to go through an accession process, and that accession process would involve a legal and political dynamic which might be difficult to predict and which might take a long time. Now, it's fair to say that both sides for a long time, insisted on the rightness of their position and weren't in particularly acute listening mode to the other side. And what I want to say is I want to say something about why it was so difficult for them to talk to each other and so difficult to reach some kind of resolution, leaving aside the fact that they obviously started from very, very different positions of interest. They wanted the conclusion to be a different one. But what I want to say is I just want to make the point that this is a genuinely difficult question not only to address, but a genuinely difficult question to resolve and see what follows from that. The first point I want to make is that there's in both cases, on both sides of the argument, it can be said truthfully that there is something unprecedented about the situation. It can be said truthfully that it's unprecedented that an EU member state should split in a context where both of the parts want to continue to be member states in the future. We have the inexact precedent and analogy of Denmark and the situation where Greenland decided it wanted to be an independent part of the Danish state and no longer to be part of the EU. But of course that's different in two respects. Greenland didn't want to leave Denmark and it didn't want to stay in the EU. So whatever lessons we can learn from that are actually very, very few. And because of the unprecedented nature of the situation, both sides of the debate drew a different inference. The inference was drawn from the UK side that normal rules of state succession should apply. And under normal rules of state succession, only one state should succeed, and that inevitably should be the rest of the UK, leaving the question of Scotland's succession or Scotland's membership highly problematic. The counterpoint made from the Scottish side was that there was no precedent for 5 million citizens being chucked out of the EU simply because they decided that they didn't want to be a member of another entity, namely the United Kingdom. These people were citizens. They were covered by the citizenship provisions, which have been in place since 1991 in the Maastricht Treaty. The EU was a constitutional entity. It wasn't simply an international organisation. And therefore, the burden was on those who said that Scotland shouldn't continue to be a member to show why. So each was trying to put the burden of proof on the other side. And each did that on the basis that this was an unprecedented situation. So who wins? How do we actually resolve this debate? How do we begin to develop an answer to that debate? Well, that doesn't really help because it rather depends upon whether we see this as a debate within international law or whether we see this as being a debate within European law, treating European law as something distinctive, or at least as a distinctive subset of international law. If, as unsurprisingly the British government, reinforced by the advice they had from their experts, Professors Alan Boyle and James Crawford, in the recent document published in February, if you start from the premise the EU is, for most purposes, simply an international organisation with some special frills attached, then the normal rules of state continuity do apply. And if you apply the normal rules of state continuity, the balance of argument is probably in favour of the rest of the UK being the continuing state and Scotland being the state which perhaps has to apply anew. And that's on the basis of a number of different arguments, precedent, also the fact that the rest of the UK in terms of population and in terms of territorial size is vastly in excess of Scotland. Likely recognition on the part of third parties is another factor. And also, quite importantly, the fact that this is a situation where Scotland wants to be independent from the rest of the UK, whereas the rest of the UK does not want to be independent from Scotland. So in that sense, arguably at least, it's different from the Czechoslovakia velvet divorce scenario, where the Czech Republic and Slovakia both wanted to go alone. So each could be treated as a successor state on exactly the same basis. Now, the reason why the international law position is not definitive of the issue is that we can also look at the special case of European law. Sir David Edward, for example, ex-judge of the European Court of Justice, has intervened very, very powerfully in this debate. He's not the only one, but he's intervened very, very powerfully to try to make the point that it is unhelpful to follow the precedent of international law when we have the more particular body or corpus of law known as European law. And if you go back to the origins of the European treaties, some of the most famous case law at the very beginning of the European Union, the Van Henden-Loos decision, also the Costa decision, talked about the EU as being a distinctive legal order. They did it gradually. In the first case, there was a distinctive legal order within international law, and then in the second case, the Costa case, they simply talked about it as being a distinctive legal order. They even dropped the international law. The point being that as a distinctive legal order, we shouldn't necessarily assume that the normal rules of state succession, such as they are, or such as they might be, would apply. And the argument of David Edwards and others has been that if you look at the treaties as a whole, including the various duties of equality, of respect for national minorities, of sincere cooperation between the member states, then looking at that as a whole, looking at it holistically, our understanding should be that everyone who is an existing member has a duty to cooperate sufficiently to ensure that a new Scottish state should be accepted within the European Union without undue obstacles being placed in its path. There's a very general argument that's being made here, but the basis of the argument is that the European Union, rather than an international organisation, as I said, is something of a constitutional club, and constitutional clubs do not eject their members or their member citizens. As a constitutional club, it's viewing its members as the 500 million citizens, not as the 27 member states. So it's not a question of ejecting member states, it's a question of taking the rights of citizens seriously. And what that argues for is some kind of process which would either, and I know Graham will talk about this, either involve a fast-track accession or perhaps no accession at all and simply an amendment of the existing treaty structure. As an accession treaty, there's an acceptance that Scotland is a new state and is a new member. If you simply have an amendment of the existing treaties, there is an acceptance that Scotland and the rest of the UK are in the same position. And so various consequential amendments have to be made in terms of the size of the Commission, the size of the Parliament, judges in the European Court of Justice, etc., etc. But beyond that, no special accession procedures have to be followed. So there we have the counter-arguments. And of course, the question then is, which of these streams of law, which of these streams of authority should prevail? And that's not an easy question to answer. And it's not an easy question to answer, partly because international law has no real standing to answer this question. There's no obvious place, such as the International Court of Justice, where you could obviously bring this question and it can be resolved authoritatively. But even in the European context, it's not easy to imagine how you would answer this question. The EU, in a sense, is an acephalous body. It has no obvious head. It's a body with all sorts of institutions, a commission, a council, a court of justice, etc. It may see itself as a constitutional entity, but it doesn't have a written constitution which gives us an organogram telling us who makes certain decisions under particular context, under particular circumstances. So it's very difficult to actually see who would decide this question. One might say the Court of Justice should decide the question, because normally within a constitutional system, it is the highest court that decides this question. But as others in this room know, it's very, very difficult to get a question like this to the Court of Justice in the first place. The Court of Justice doesn't have any obvious standing here, and it has no obvious advisory jurisdiction. The Commission, in some of its comments, has seemed to assume that it is the source and fount of legal wisdom in these matters. But it's not. The Commission is just the executive agency, perhaps the bureaucracy of the European Union. What it says matters, but it's not authoritative in legal terms. Perhaps it's the Council of Ministers, because they are actually a very, very authoritative body when it comes to the initiative of reform. But again, it's not entirely sure who will decide. So not only don't we know the answer to this question, but we don't really know who should decide in the case of dispute. And that is why, sorry, how many minutes have we got? Another five. That is why I think this has to be finally seen as a question of politics as much as a question of law. The law is not unimportant. I'm not trying to be cynical about the law here. I think it's important that people bring the best legal arguments to the table, because the law contains with it some kind of moral authority. some sense that this is proper international or supranational legal practice. So we need to have that argument, we need to have that debate. My point is simply that having had that debate, it's very, very difficult to come to an obvious resolution. You know, either there needs to be an accession treaty, or there simply needs to be a complex amendment treaty which would affect all the interested parties, both the rest of the UK and Scotland. But in a sense, regardless of how that question is decided, it does mean that there's going to have to be a process which involves negotiation with all of the other member states, and that nothing can be agreed unless and other than with the unanimous agreement of all these member states. Whether we're talking about a new accession treaty or whether we're simply talking about an amendment treaty to bring new Scottish representation onto the table and to make all the necessary institutional and financial adjustments, you're still going to need some kind of treaty reform. And if you need treaty reform, you have the double lock of unanimity on the part of the executive representations, but also ratification in accordance with the constitutional rules of the member states, which could run from anything from a parliamentary vote to a referendum. So whatever way we do it, this has to be a political debate. Which brings me to my final point. There are then many, many issues are on the table, including questions of justice and home affairs, the euro currency, etc., etc. Many issues, the budget. But one question which is raised, which stays at the level of the fundamental question of whether and in what terms Scotland should be admitted, is the question of whether they're going to be subject to opposition to those member states who have their own concerns about their own national minorities. And this is a question that everyone's aware of, particularly in the context of Spain and Catalonia. But there's a wider context, which our chair, Peter Jones, has reminded us of in an article in The Scotsman this week, which reminds us that a number of European states, not just Spain, but also Cyprus, Greece, Slovakia, and Romania, and one more, no? Yeah, have refused to recognise Kosovo and have made it impossible for the EU to refuse to recognise Kosovo because they are concerned about the minorities in their own doorstep. Obviously Cyprus, it's Turkish Northern Cyprus. In the case of Romania and Slovakia, it's the problem of the Greater Hungary. In the case of Spain, it's clearly the question of Catalonia, and maybe the Basque Country is still in the background. And the argument goes that these countries will be very, very loath to do anything which makes the possibility of Scotland being admitted, or to put it more mildly, Scotland being admitted on favourable terms. They'll be loath to do anything to make that more likely. What do I think of that argument? Well, I want to make 2 points in conclusion about that argument. The first is a general point, which is that it's very easy to make these sorts of points in advance. It's very easy, to issue these sorts of vague threats about the possibility of obstruction, etc., etc. But at the end of the day, these states have to act in a context of public reason. You have to give good public reasons. They have to say, here's the reason why we wouldn't want Scotland to come in on its own terms. And these reasons would have to make sense in terms of the history of the European Union. The history of a European Union which started with 6 countries, which now has 28, which admitted 10 Central European countries within the last 15 years, which is committed to national self-determination. It's going to be difficult to make a special case against Scotland in that context. And secondly, it's going to be particularly difficult because Scotland's position vis-à-vis the UK is very different from the position of Turkish Northern Cyprus vis-à-vis the Cypriot state, or the question, or the danger, the looming danger of Greater Hungary in the context of Slovakia, or in the context of Romania. And the reason for that is that, or even in the Spanish context, Spain and Catalonia, the reason for that is that, as we know, we're in a constitutional process in the UK context, which on the one hand, is not the velvet divorce of the Czech Republic, of Czechoslovakia, where both sides want out. But on the other hand, it's not a situation where the metropolitan centre of the state, so to speak, is actually saying that it's constitutionally unjustifiable for the part to secede. If Scotland does secede, it may be against the political wishes of the majority in the rest of the UK, but it will not be against what is assumed and acknowledged to be the proper constitutional procedures. So it will be a secession which is consensual within the UK state. So if one is looking to draw a distinction between the Scottish situation and the situation of some of the other national minorities in the rest of Europe, then I think that distinction can be drawn on the basis of the higher constitutional legitimacy. And that matters, because if the argument against national minorities is that we have to take existing states seriously, well, if the existing state itself can accommodate the possibility of secession, then the way in which you take the existing state seriously is to take seriously the fact that it can accommodate secession. Now, I think a more general argument can be made about national minorities. Again, a more favourable argument in terms of continuity. But that's not the argument I want to make today. So I'll leave it at that. Thank you.
Is going to talk more now about the process of Scottish accession.
Well, thank you very much. I'd like to begin, ladies and gentlemen, with two declarations about my identity. I'm not Scottish. My father was English, and my mother was Welsh, and I was born in Wales. And believe me, if your mother is Welsh and you're born in Wales, you're Welsh. I sometimes say my nationality is Welsh, my passport is British, and my citizenship is European. And these three parts of my identity, they're complementary, they're not contradictory. So I want to make it clear from the beginning that I'm relatively objective on this question of Scottish independence. But I'm a fan of Scotland. When I was a student at Oxford University, my parents lived in Glasgow and then in Greenock, and they were very happy there, and I fell in love with the Scottish mountains. Later, my son climbed his first mountain on the Isle of Arran, and that's almost as good as being born here. Anyway, the second declaration I want to make is that I'm not a lawyer or a legal expert. I'm almost ashamed to admit it in this distinguished company, but I made my career in the public service for 40 years, in Whitehall and then later in Brussels, without a degree in political science. I learnt the science of politics on the job. I was a very junior member of the British team negotiating membership of the European communities, and later I was one of the architects of the big enlargement of the European Union to bring in the Central and East European friends. And I think if I have any claim to be an expert, it's probably on how to join the European Union. I've made a calculation, which is that I took part in 23 accession negotiations in one way or another, and when I worked for the Commission, I produced 14 opinions on applicant countries. And in fact, it was this experience with the enlargement of the European Union that led me last year to this question of Scottish independence. Last year, I read and I listened to people in London, highly placed people, explaining that an independent Scotland would have to go through the traditional procedure for joining the European Union, just like any other non-member state. This struck me as so absurd and unlikely that I decided to put in my pennyworth, and last September I submitted a memorandum to a committee of the House of Commons explaining why the procedure for Scotland to join the European Union would be different, simpler and quicker. It's what I call the common sense approach to enlargement, and that's what I want to explain to you tonight. I need to make another declaration. Although I worked for 33 years for the European Commission, I retired 7 years ago, and I no longer speak for the European Commission. Sometimes, not very often, I disagree with it, but I want to make it absolutely clear that I'm not speaking tonight on behalf of my former employer. actually, it's not exactly clear what is the position of the European Commission or of its President Barroso on this question of the procedure for Scotland's accession. But I think I'd better leave the explanation of the Commission's position to a representative of the Commission. Is there one here? Good. Anyway, what I want to try to explain is, first, what is the traditional procedure? Second, why it's not appropriate for the Scottish case. And thirdly, what exactly is this solution of common sense? Now, the traditional procedure, the famous accession process, is laid down in Article 49 of the EU Treaty. It's what's been followed by Turkey, for example, or more recently by Croatia. In about 100 days, Croatia will become the 28th member of the European Union, and basically it's the procedure where non-members become members. What does it involve? It involves a lengthy opinion of the European Commission on whether the applicant can comply with the political, economic, and administrative criteria for membership. This is followed by a chapter-by-chapter negotiation with the applicant country in an intergovernmental conference, 35 chapters, 35 or more negotiations, and a regular annual report by the Commission on the progress of the applicant country in fulfilling the conditions for membership. All this can take up to 10 years. It took Poland, Hungary, more recently Croatia, 10 years. Now, would this be appropriate for Scotland? Absolutely not. It's perfectly evident, and for two reasons. First of all, Scotland is already in the European Union. It's been a member for the last 40 years by being with the United Kingdom. Now, of course, there's no precedent, as Neil explained, for an existing member state to separate and divide, and both parts stay in the European Union. And there's no article of the treaty which tells us what to do in this case. In fact, it's not even a case of enlargement of the European Union. It's accession, but it's not enlargement. There's an interesting precedent. It's not exactly a precedent, but that was when Germany reunited in 1990. That was a case of enlargement without accession, because the German Democratic Republic joined the Federal Republic of Germany, and that's how 16 million East Germans joined the European Union. The second reason why the traditional procedure is not appropriate is that it's not in the interest either of the European Union as a whole or of any of the member states for Scotland to leave the European Union and then apply for membership from the outside. To have a situation where for an indefinite period Scotland would be a non-member, it would be necessary to design a relationship between Scotland and the European Union. And even if that relationship was as close as the European Economic Area, which is the most intimate relationship the European Union has ever negotiated with a non-member, even then it would mean three things. It would mean Scotland no longer paying into the European budget as it does now through the UK budget. Secondly, it would mean that Scotland's territorial waters would be outside the European Union and outside the common fisheries policy. And third, it would even mean customs controls at the border between England and Scotland, because that's part of the EEA. Does this make any kind of sense from the point of view of the European Union and its member states? Plainly, the answer is no. So let's proceed to look at what the common sense solution might be. That means simply using the period between the Scottish referendum and the date of independence to sort out the conditions for Scottish membership of the European Union, so that the necessary changes to the European treaties can come into force on the day of Scottish independence. Now, as Neil explained, it's perfectly, as I want to explain, it's perfectly possible for the EU to invent a simplified procedure in order to do this. In fact, that's exactly what it did in 1990 to handle the German case. The big difference between Scotland and Germany in this context is that there wasn't a modification of the treaty in the German case, but there would have to be some modification of the EU treaty as a minimum to provide for Scotland's representation in the European institutions. And as Neil said, modifications of the treaty, they require unanimity. And that means any of the 28 member states could delay or block the process. I just want to say a word about Spain here, because plainly Spain is particularly concerned and particularly tricky, because in Catalonia there's a lively separatist movement. Madrid is very worried about that, and it doesn't want to encourage the separatists in Catalonia. That's why Spanish ministers sometimes take a rather hard line in public on Scottish independence. Actually, in my opinion, their gripe really should be with London, because London has agreed with Edinburgh for a consensual process, which Madrid is not prepared to agree with Barcelona. But anyway, as far as Spain is concerned, I think the question is whether this hard line would stand the test of reality. Would Spain really insist on Scotland, first of all, leaving the European Union and then applying to rejoin? Personally, I think that in Madrid, the finance ministry, for example, and particularly the fisheries ministry and a number of other ministries would say, for heaven's sake, let's not shoot ourselves in the foot. It would be against our interests for Scotland even to leave the European Union for a short time. And my Spanish friends tell me that politically the Spanish people would naturally accept the result of a democratic process in another country. Now, up to now, I've talked about the procedure for joining the European Union, and I want to conclude briefly by commenting on the substance. What could be the terms of Scottish membership? Well, the main treaty change, as I've said, would be to provide for Scotland's representatives in the institutions of the European Union, the European Parliament, a vote for Scotland in the Council of Ministers, and a Scottish Commissioner. These institutional changes would be uncontroversial. They wouldn't be difficult to negotiate, although it's possible that the rest of the United Kingdom might perhaps have to accept some small reduction in the number of its members of the European Parliament. The next question concerns the Eurozone and Schengen. Should Scotland stay outside the Euro and outside Schengen? Will it be obliged to join the Euro or to take part in Schengen? And the answer is quite simply no. New member states are not even allowed to join Schengen or the Euro on entry to the European Union. Poland, for example, is still outside the Euro after nearly 9 years of membership. Even old member states, like Sweden, are not in practice obliged to join the Euro, despite the fact that it doesn't formally have an opt-out. The EU has neither the means nor the will to oblige unwilling members to join the Euro. As far as Schengen is concerned, Ireland's not a member of the Schengen zone either. So an independent Scotland wouldn't be obliged to join the Euro or Schengen, but in the long term, you might decide in the long term that it's in the national interest. So perhaps you should think about an opt-in rather than an opt-out. Now, the third question I want to address, and this doesn't involve changes in the EU treaty, is possible changes in the secondary legislation. What position would Scottish representatives take on the application of the fisheries policy in Scotland and on the budgetary system? And here my experience tells me that the best solution, both for Scotland and the EU, would be a transitional arrangement in which the existing arrangements for Scotland would be rolled over, mutatis mutandis, until the next time when the EU's rules come up to be reviewed and revised. In the case of the budget, that's in 2020, and for fisheries, sometime around the same time. And at that time, an independent Scotland would have a full voice and a full vote in the EU decisions in those areas. But let me be honest, one of the trickiest questions would be the budget, the adaptation of the existing British budgetary rebate to take account of Scottish independence. And this would be a very difficult negotiation between London, Edinburgh, and the other members. One last word. In the pre-independence period, Scotland wouldn't yet be a member state of the European Union. in the intergovernmental negotiation for Scottish membership of the EU, the British government would have a vote and a seat at the table. The Scottish government would, I'm sure, be represented, but it would need the constructive cooperation and support of London. And this would be a big test of the Edinburgh Agreement. But I'm rather sure that the British government in London would strongly defend what I've described as the common sense solution for the simple reason that the alternative, an independent Scotland outside the European Union, would be so problematic, not only for the EU as a whole, but particularly for the rest of the UK. But what if at the time the UK is engaged in a renegotiation of its terms of membership, leading to a referendum on EU membership, as Mr. Cameron has just promised? Well, it certainly would complicate matters, at least for London, but it would also put Scotland's situation and prospects in a different light for the other EU members. The Scottish people have always had a more solid understanding and appreciation of the aims of the European project than those people down south. The EU is a historic experiment in creating a community of peace and prosperity. It's a work in progress to which Scotland and Scots men and women have already contributed greatly. I'm convinced that you will continue to do so. Thank you.
Thank you very much indeed, Graham. Now Diana Pankey, who's going to talk about the influence of small states within the EU.
Exactly. Well, good evening, everyone. My name is Diana Pankey, and now we're moving from a Scotsman to a Welsh over to a German person, but I guess that's all a coincidence. What I'm going to do in the 15 minutes that I have is to briefly talk about lessons that we can learn from other small states, or from small states in the European Union, in the day-to-day operation of the European Union, for an independent Scotland as a member of the European Union in the EU. So in other words, the lesson learned theme that we basically had in the two other talks is going to continue in my talk as well. I'm a political scientist, so what I'm going to do is to basically provide you with a political scientist's perspective on the operation of the European Union with a special emphasis on the role of small states. The talk is based on two assumptions, though. The first assumption is, well, that the referendum is basically leading to the independence of Scotland. And the second assumption is that Scotland then exceeds the European Union. The question then is, well, if Scotland then is an independent member of the European Union, if it is a small state in the European Union, what are the challenges that Scotland as a small state faces? And what can we learn from what other states are doing in the European Union for Scotland in order to basically enable it to punch above its weight in day-to-day EU negotiations? Okay, so that's basically the program for the next 15 minutes. I did a research project on small states in the European Union roughly 3.5 years ago. And what I did was starting out with a survey that had been circulated in ministries of all 27 member states and also in the missions, the permanent representations in Brussels of the 27 member states, asking the practitioners sitting on the negotiation table in the day-to-day operation of the European Union, how frequently they use different negotiation approaches and how influential they are in basically influencing EU law, European directives, European regulations in line with their own preferences. So what were the main findings? The main findings first in regard to activity where, well, some states are way more active at the negotiation table than others, meaning some states are using, well, argumentative strategies, framing strategies, bargaining strategies, lobbying, coalition building, networking, and so on and so forth, way more often than other states. If we have a closer look at this activity mapping, we actually see that it's not all a story about big versus small. Bigger states are more active than smaller states, but if we have a closer look, we see that there are some smaller states, such as Luxembourg or Ireland, to name just two, that are more active, more engaged at the negotiation table in Brussels than other states such as Greece, for example, or Portugal, or many of the new member states, Malta, Cyprus, the Baltics, and so on and so forth. So what I did in the research project was first of all looking at, well, how can we explain that some states are more active than others? And then in the second step, I looked at influence. And the influence mapping also revealed that there is a considerable variation between states. Some states manage to influence EU directives, EU regulations way more often in line with their own positions, their own preferences than others. And again, it's not only a story about big versus small, but if we have a closer look at smaller member states, we see that there is considerable variation. Again, some states, outperforming here is Denmark, for example, are way more influential than other small states, such as, for example, Portugal. So the second question that I asked in my research project was, well, how can we explain that some small states manage to be more influential than others? Okay, and I'm basically giving you the answers in a nutshell, and then move on to, well, what can we actually learn for an independent Scotland as a member of the European Union in the future? Okay, well, first of all, in terms of activity. In terms of activity, the major finding was, well, it is not so much a lack of willingness if smaller states or diplomats, attachés from smaller states are at the negotiation table in the working groups of the Council of Ministers and are actually silent to some extent. Rather than willingness, it is very often capacity that is lacking. And the most important finding in that respect was that very, very often for small member states, the problem doesn't lie in Brussels and the permanent representations there, but in the ministries back home. Usually when the European Commission drafts a new regulation or a new directive, it basically sends the proposed law to the Council, the Parliament, consultative committees, and the Council members then basically forward the whole thing back to the line ministry in the respective capital. And the line ministry usually then starts to, well, engage in an analysis. What's the status quo of the legal framework back home? What are the changes that are proposed from Brussels? What would be the implications? And then it goes on with an impact assessment on different implications. And on that basis, ministries develop national positions. On that basis, ministries formulate instructions and they send those instructions back to their diplomats, their attachés in Brussels, who are then taking the instructions to the negotiation table and start negotiating on that basis. Well, that's at least the ideal world. In reality, though, in many small states, the capacities are really very limited in the ministries back home. That might be that there are no EU divisions, or the EU divisions in the ministries, in the line ministries, are really, really small. And at the end, that means that for some directives, some regulations, there are either no instructions coming from the capital, or, and that's more often the case, the instructions that are coming from the capital arrive A, with a great delay. When the negotiations in Brussels have already started, the diplomats at the beginning do not really know what the position is that they should defend. Or the national instructions are really rather, well, basically vague, identifying 1 or 2 points that the diplomat should take care of, that it's written in EU law, but do not give much background analysis, do not provide much expertise that the diplomats can use at a negotiation table in order to persuade their colleagues from other member states. So in other words, what happens if national instructions are arriving really late or only focusing on some points, not providing much background expertise, is that as a result of that, the attachés and diplomats tend to be rather silent at the negotiation table in Brussels, either because they don't know what national position they should defend, at least at the beginning of negotiations, or because they don't have much background expertise, much arguments that they can use at a negotiation table in order to make the most for their country. So that's basically one of the main reasons of why some member states are more active than others at the negotiation table in Brussels. In regard to influence, the mapping also revealed that there is considerable variation between member states. Some are more influential, others are less influential. The question is how come? And that's even a more important question, obviously, than the question of activity. Yet the most important finding is activity and influence are greatly interlinked. In tendency, the more active diplomats and attachés participate in negotiations, the greater are the chances that they can actually win some points, that they can actually influence EU law and EU directives. But apart from being active, it is also really important that diplomats participate from early on and not only at the very end of negotiations, and that they use negotiation strategies for which they possess the required resources. In other words, it's not really of use to start bargaining if you don't have much bargaining leverage. It's not really of use to basically threaten a veto if it's clear that the veto is that you're not in a pivotal position, that you can simply be outvoted. And also, it's not much use to start technical arguments if you don't have the expertise at hand. So in other words, active participation from early on is important. It is important that you use negotiation strategies where you have the capacities at hand. And it is also important that the strategies that you are using are actually fitting to the issue at stake. So if it's a really technical issue, what you really need is technical expertise. If it's a normative question, what you really need is good normative arguments. So that, in a really condensed nutshell, was the major finding of the project. Now, applying that to Scotland. First of all, the question of if Scotland would be independent and having acceded the European Union, what are the challenges that Scotland, as a small state in the EU, would face? Well, it's basically the same challenges that other small states are facing. That is, well, first of all, when it comes to weighted voting at the Council of Ministers, Scotland would have lower weight, a lower number of votes. Under the old system, once the Lisbon Treaty changes apply, due to a limited population of roughly 5 million, it obviously would have less leverage than bigger states such as the UK or France or Poland or Spain or Germany for that matter. So the first challenge of small states in the European Union is that they are sitting at a negotiation table, but they have less formal weight than bigger states when it comes to voting at the highest level of the Council of Ministers. Another challenge that Scotland would face in the European Union is, well, its ministries are smaller back home than the ministries of bigger member states, which renders the production of national positions of instructions that are then submitted to the Scottish diplomats in Brussels way more difficult than if you have a ministry where, well, more than 1,000 people, 1,500 people are working in highly specialized units. So staff resources back home can be a challenge. So those are basically two major challenges, and the question is, well, how would Scotland actually manage to make the most out of EU membership given those limited capacities? And we just heard that capacities matter for activity, and since activity is crucial for influence, capacities actually matter more or less all the way down to influence. Yet what we saw in that particular research project is that small states have by no means tight hand. Some small states with, well, kind of comparable capacities are way more active, way more influential than others. So it cannot be all a story about capacities, and that's the important point for countries that are small, for countries such as Scotland. So what can Scotland do to punch above its weight? Well, the first thing is to basically know what it wants. Small states cannot be good at everything. Small states cannot negotiate with full force in regard to all issues that are at the negotiation table in the various working groups of the Council of Ministers. So what Scotland would need is a very, very clear strategy and priority list when it comes to EU politics. What is most important? Where should priorities be set? Where should capacities be devoted on? And what issues are secondary or tertiary and can therefore be ignored if capacities are insufficient? So that is one very important thing, to basically establish a system in the different line ministries, but also in the Ministry of Foreign Affairs, that allows for the prioritization of issues in order to make sure that the capacities that are available are made best use of. The second thing is learning in line ministry, creating institutional knowledge in line ministries. At the very end, when it comes to preparing positions that can be carried to the negotiation table in Brussels, it is essential that the ministerial bureaucrats back home not only have knowledge about the importance of the European Union and the issue at stake, but are also willing to devote their limited time, because in the end they are facing capacity problems themselves, their limited time into working on EU matters rather than national matters, in quotation marks though. The ministries with the strongest, or where the staff has the strongest EU support are usually the ministries that are most active and that are basically preparing the best instructions, and that then basically helps the national diplomats in Brussels to be active and influential. So institutional memory, prioritization, and the system of prioritization would be key issues in order to outperform in Brussels. Apart from that, if we are basically looking at the Brussels end of things, it is really important that the diplomats are proactive, not passively waiting till an issue is coming on the negotiation table in the working group and then starting to basically just read out the national positions. It's that if something is very high on the priority list, it is crucial that diplomats reach out proactively to their colleagues in the Council of Ministers, but also to other institutions, the Parliament, and to some extent also the European Commission, in order to make sure that they get the biggest crowd for their own points, the greatest support for their own points. So in a nutshell, those are things that are key for small states to punch above their weight in the European Union. The states that are most active and the states that are most influential usually have relatively efficiently organized ministries back home. They usually have a high level of institutional knowledge, both about the operation of the European Union and about past policies, past EU policies and past negotiations at hand. They have motivated civil servants who are willing to devote their limited time to EU issues rather than issues that could be labeled simply pure national issues. And they have motivated and engaged diplomats at the negotiation table in Brussels. And in this regard, if we compare Scotland to many of the new small member states that exceeded the European Union, Scotland has a very big advantage, or actually two big advantages. The first one is language. Being English native speakers, Scottish diplomats can communicate way more easily to their colleagues in Brussels than, for example, the diplomats of Cyprus, the diplomats of the Baltic states, also small states that basically joined the European Union in the 2004 enlargement. The second advantage is that Scotland doesn't start from zero. Although there is no Scottish diplomatic corps and although there is no Scottish mission in Brussels that basically represents national interest and defends national interest at a negotiation table to shape EU policies, so being part of the UK, British diplomats already and British civil service or Scottish, Scottish member of the British Civil Service, Scottish members of the British Diplomatic Corps already collected experiences of how the EU works. They already set up a network to other member states, to the Council, to the Commission, to the other EU institutions. And that is something that can basically boost the influence of Scotland from the very beginning. Okay, that was basically my part of lessons learned for Scotland and the EU.
Thank you very much indeed. If I can sum up what people have said in very crude journalistic style, which I'm allowed to do because I'm a journalist, not an academic. Scottish accession to the EU, international and European law is not a terribly good guide or to how that would happen or whether it would happen, but the evidence generally suggests that it's highly improbable any state or organ of the EU would bar the way to Scotland to getting into Brussels, although some might want to put some bricks on the rails and make it a bit bumpy. Secondly, Scotland will not be facing a long drawn-out accession process as other states have done, according to Graham Avery. Instead, there will be a variety of transitional arrangements which will ease Scotland's path into the EU. And once in the EU, Scotland could well have quite a reasonable degree of influence. It just depends on how much hard work we're willing to put into it, essentially. So, we're now going to move to questions. I would remind everybody that I would like them to identify themselves as possible, as this is being recorded for posterity. But before I do that, Graham Avery, helpfully for us and perhaps unhelpfully for the person concerned, identified a member of the European Commission here, and I wondered whether that person would like to comment on anything which has been said so far. There are microphones at the side of the room which will become available. Do you wish to make a contribution, sir?
As I said, the European Commission is a. So the European Commission is a is not pronouncing anything on this. It's just witnessing what's happening.
Thank you very much. Right. Okay. Who would like to hand up at the back up there first of all?
Thank you, Peter. My name is Derek Young, for the benefit of the recording. I was struck in some of the contributions about the fact that whether it's a formal accession process or a treaty amendment, it will inevitably require treaty changes. And that will therefore also require not just the unanimity amongst the member state governments, but also ratification processes within each member state. As of last year, in the UK, there is now a requirement under the European Union Act 2011 that if there are treaty changes, those require to be put to a referendum of all UK voters as well. So it's not just a question of David Cameron saying yes or no, but the UK electorate might have to approve or disapprove the terms of Scottish accession. And my question is, would that affect the negotiations, that factor, between Scotland, the UK and the other EU member states? And what would happen in the event of the UK electorate rejecting the possible terms of accession or treaty amendment? Would we see a sort of second referendum, as we've seen in other processes in other countries? Thank you.
Derek, before you your designation is, sorry?
I work for the British Red Cross, but I'm not representing them here, just as Graham Avery is acting independently.
Graham, would you like to address that question?
Yes, I think perhaps there's a misunderstanding because the legislation which was passed at Westminster provides for a referendum in the case that powers are passed from the UK to Brussels. And in fact, it's quite interesting that in the catalogue of cases that they list in the Act, They don't even mention enlargement to bring in new member states. So frankly, I don't think this recent legislation on referendum would apply in the case of Scottish independence.
Okay, thanks very much. I should say to people who are in the overspell room, whom I can't see, that if they do wish to ask questions, please come to the door beside the hall where your question will be gratefully received. Next questioner, please. Down at the front here.
I'm John Purvis. I was a MEP for 15 years, representing 10 of them Scotland and 5 of them Mid-Scotland and Fife. I just wondered if you wouldn't turn your attention to the European Parliament's role in this. You've, Mr. Avery and Professor Walker, both mentioned it's a very political issue, this, rather than purely legal one. Professor Pankey didn't actually mention the European Parliament very much, but I have a feeling that parliamentarians will be very much involved in whether Scotland it gets an easy route in or not. And would they like to comment on that?
Fair question. Is this just a game for states to play, or do European parliamentarians get a role in it? Neil?
Yes, I mean, you're right, and perhaps there should have been more mention of the Parliament. I mean, clearly, if as you know, if you're talking about treaty amendment, there is a role for the Parliament, you know, within that process, and so the Parliament would have to be part and parcel of the formal debate. Of course, I think you also raise a more general question, which is that, and it's one which I hinted at in my own contribution, that there has to be some process which generates some kind of European opinion on this matter, which goes beyond the occasional statement of a Spanish foreign minister or the smoked-out statement of the head of the European Commission. and the place in which that might be found, presumably, is the European Parliament. But of course, the European Parliament would have to take it upon itself to become involved in that debate. And it actually might be quite an empowering thing for the European Parliament to do. But whether or not it will do that is I'm not sure.
Diana, do you want to add to that?
Well, the focus of my talk was rather on what happens if Scotland would be independent and already a member of the European Union. And the only parliamentary aspect that I haven't mentioned in that regard, and I'm happy to add now, is that obviously in order to be influential, it's also important that, well, the diplomats, the attachés, represented in the council for the different member states outreach to the different institutions, basically create alliances with the parliament. And in that respect, obviously the more seats a country has in the European Parliament, the better, because first of all, those are the natural access points in order to try to basically get a feel for the parliamentary opinion and try to basically create support for one's own position. So in that respect, the Parliament is definitely important as well. Yeah.
Okay, next question. Question at the side, just here.
Thank you. My name is Ewan Sutherland. I do work in the telecommunications sector. And so my interest and expertise in this comes from what at one time was Chapter 10 in the accession negotiations. Now, my question is this. If you accept the position of the Scottish Government, you have about 18 months, give or take, a United Kingdom general election between the referendum and independence. If you assume accession to the European Union on the day of independence, you have to be compliant with the acquis communautaire fully. Now, one of the reasons accession has taken 10 years in some cases is you have to put the laws and the institutions and the processes in place. Now, if you go through an accession process, you get ready. If you automatically or fast-track become a member, the treaty means all of the acquis is applicable on the day of independence. There could be a lot of very wealthy lawyers in Edinburgh bringing legal actions against the Scottish Government for failing to apply to the acquis. Could you fast-track the acceptance of the full, I think it's 150,000 pages at the moment, of the acquis? Could that be done?
Graham, one for you, I think.
Well, all I would say is if Scotland is presently not fulfilling its obligations under the EU Treaty, then the lawyers ought to be at work already. I'm not an expert in Chapter 10, excuse me. All I would say is this, that plainly in the common sense approach which I've explained, there would have to be a technique for handling the secondary legislation. The vast mass of the secondary legislation wouldn't need any adaptation at all. There might be one or two cases. I'm sure there would be some cases where you'd have to make special provision, maybe for some transitional period for Scotland. But I think there would need to be, and this would be the job of the European Commission, there would need to be a rapid examination of, it's not 150,000, it's only 80,000 pages. They'd have to scrutinise it, they'd have to do it with the aid of Scottish experts, and they'd have to report in time for this accession treaty for Scotland, they'd have to report on whether any modifications were required. And I'm absolutely convinced that the vast majority of them would be uncontroversial because you've been applying the acquis here for 40 years.
Yes, I think the salient point is that quite a lot of the acquis is already in Scottish law. I mean, some of it deals with things like environment. For example, the Marine Scotland Act of 2010 incorporates EU law on the marine environment. But a lot of trade law and trade and financial law is not, because that's part of UK law. So it does still, assuming, let's say, maybe there's 50,000 pages of which are not in Scots law, it does involve maybe passage of 50,000 page law book into Scottish law. I'm not sure how quick that can be. Anyway, next question, lady down here. Oh, sorry.
My name is Penny Jankinelli, and I'm a New Scot. That's why I have this accent. The assumption is that Scotland, an independent Scotland, would necessarily join the EU when there are clear advantages to not joining. Is there any reason not joining is not discussed as an option? After all, the fish belong to us, the oil belongs to us. I mean, us new people. Okay.
Quite a good question, which we haven't really put on the agenda. Do you want to have some, Neil, a brief comment on that?
Funny how the New Scots are more nationalistic than the Old Scots. I think I looked at James Mitchell's book recently, which was on the composition of the Scottish National Party, and there still is a minority of people in the Scottish National Party who are non-Europeans, despite Jim Silla's rallying cry of 40 years ago of independence in Europe. And but it is a small minority. It's about 10%. There's also been talk in the last few weeks of the UKIP effect, the fact that the UK Independence Party, the kind of little Englishness which we see associated with that, might have its analogy in Scotland. But I don't think either of these amount to a particularly strong process, and there doesn't seem to be much in the present debate which would push in that direction. Of course, one scenario, what you're doing is you're emphasizing the possible positive of being outside. I would rather see it in other terms. I guess if some of the eventualities which we talked about came to pass, and many, many obstacles were being put in place of membership, then that might be the catalyst for a change of political opinion. But as I say, I think that's probably unlikely. So it's more likely to be the sticks, of staying in, which make people think again, there are the carrots of being outside that make people want to vote for Scottish independence without European Union membership.
Yes, there was a recent poll in the Times newspaper which said, I think, that around 58% of Scots thought there ought to be a referendum on EU membership. But rather interestingly, that same sample divided 60-40, I think, in favour of EU membership. And if I can just quote Sir John Kerr, who's a Scot and a former permanent representative to the EU. He wrote recently, outside the EU's single market, Scottish trade would certainly suffer, particularly if the residual UK remained inside. Inward investment from Asia and America would fall sharply, being cut off from EU research funding, and Erasmus and other exchange programs would affect the university sector. Some would miss EU structural funds. Autonomy from the EU common fisheries policy might be welcome, and the financial services industry, no longer subject to EU laws, would probably contrive to find a new niche role. But on balance, he writes, insularity might look attractive. And that, I think, actually pretty much sums up Scottish opinion on that. Anyway, a question just here.
Catherine Smith, since we're talking about political economy, could I ask the panelists if they have any ideas on the figures involved, quite apart from the number of very highly paid lawyers who would be employed in all this, in the enlargement of the bureaucracy in Scotland that would be required in order to enable Scotland to punch above its weight? Because obviously here, while Scotland is extremely good at importing highly paid, experienced people, we still have to pay for them. And obviously, if we knew how much we had to pay in advance to be able to punch above our weight, it might give us a view on whether we wish to be independent.
Okay. Diana, do you have any idea? You mentioned the more effective states in Europe. How many people they employ on these tasks?
Honestly, I would have to look that up because the project is finalized for 3 years by now. Although, I mean, I did more than 100 interviews in that project as well, and it was never a question of, well, is it not worth having a well-staffed bureaucracy in order to, well, effectively work in Brussels? So from the practitioner's point of view, it definitely seems to pay off. But from an outsider's point of view, I would have really no way of calculating what the surplus would be of Scotland being an independent member of the European Union with a very slim bureaucracy compared to what Scotland would get out of EU membership if it would have a beefed up bureaucracy that works really, really efficiently. So that simply would basically be mere speculation. So I'm sorry, but I can't really answer that question.
Okay, Graham.
I'd like to reply on two aspects. First of all, on the question of the bureaucracy required to implement EU regulations here in Scotland, I see absolutely no need to employ one additional person. You already have highly talented people here in the Scottish ministries. They spend a certain amount of their time trying to sort out London. They would no longer need to do that. They could divert their time to sorting out Brussels instead. Secondly, you would need to create a Scottish diplomatic service and a foreign ministry. That's inevitable. That is a necessary part of being an independent state. And yes, you'd have to create a foreign service. I've no doubt that the talent exists. You already have a very effective Scottish representation in Brussels, and there are many talented Scots in the British Foreign Office. Perhaps some of them would like to transfer to the Scottish service.
Okay. Questioner in the centre here.
Thank you. My name's Bill Scott, and I represent the Save the Union campaign, which is a people's organisation against Scotland becoming independent. What I'd like to ask is, Mr. Avery, he says that it wouldn't be necessary for Scotland, an independent Scotland, to join the euro. Now, I know he's an expert, forgot more about this than I'll ever learn, but there's other experts said exactly opposite, that Scotland would have to join the euro. On the assumption that Scotland had to join the euro, could you explain the financial implications this could be for the likes of Scotland, bearing in mind what we see in our televisions about Greece, people's pensions, etc., jobs being lost. What is the implication, would you think, for Scotland as an independent country having to join the EU?
Well, I think with respect, we have to address the question first, whether Scotland would be required to join the euro. Graham?
You're perfectly right, sir, to say that there are different opinions which have been expressed on this. The problem I have with those who argue that Scotland would be necessarily obliged to join the euro is this. How is it that Sweden, which doesn't have an opt-out from the euro, is not in the euro? And the answer is very simple, that in practice, you only join the euro when you meet the criteria. And whether or not you meet the criteria is optional, and any central banker can tell you that's the case. In the longer term, and I want to be frank and serious about this, in the last 20 years, the central core activity of the European Union has been the single market. That's, to be in the single market means being at the core and center of Europe. In the next 20 years, the Eurozone is likely to greatly increase in importance. And if you're not a member of the Eurozone, then you are quite likely to find it being uncomfortable in the circle of second-class members. And therefore, I think in the longer term, an independent Scotland needs to think not about the ideology of joining the euro, but about whether it would be in the long term in your national interest. That's a debate for after membership, not before.
Neil?
Yeah, just one minor, it's not so much a qualification, but just a refinement of that. We shouldn't read too much into the Swedish and the UK analogy, because they were members before the euro was in place. And it's certainly been the case that those countries which have joined since the euro have joined on the basis of the commitment that they would in due course become members. Now, of course, that does not gainsay Graham's point, which is that you can't become a member until you meet the various convergence criteria. And meeting the convergence criteria can be a formidable obstacle, and one which is easily, both difficult to obtain and also, in a sense, easily manipulable from the point of view of the perspective of the country which doesn't want to obtain them. But the position of those countries which have joined after the euro's been in place has been subtly different from those who were members prior to, and who either negotiated an opt-out or who chose a go-slow policy, as in Sweden, as in the Swedish example.
Yes, my understanding was that new member states are required to give a commitment to join the euro at some point in the future, but the point at which of joining is never defined and therefore never need be fulfilled. And the EU has no means of compelling anyone to join the euro. Is that correct?
That's correct. But I think that would be, but in that sense, so it's a stronger political obligation or a stronger sense of political commitment than existed for those who actually initially negotiated the euro and showed greater or lesser degrees of enthusiasm for that. How that works out in practice, I'm not entirely sure. You know, we can't on the one hand say, as I said earlier, that there's a commitment on the part of Europe to be good Europeans about Scottish membership and to accept that Scotland wants to be an independent state. And then on the other hand, utterly disregard the fact that Scotland would also owe certain political obligations to the rest of the European Union to be good Europeans. So if they make that commitment, it might not simply be a paper commitment. We can't tell. It might not be a paper commitment. It might be something which is taken very, very seriously in the years to come.
I've always thought that one of the ace cards in this debate, which nobody really mentions, is the European Convention on Human Rights, which all member states are signed up to, and therefore lays down a kind of a body of law and of practice which says basically everybody should behave decently towards each other and not be nasty. And that seems to me to actually be quite an important thing in determining whether or not Scotland gets into the EU and whether or not it's treated badly in the process of getting in.
I think it's taken as assumed that you know, in the context of the Central and Eastern European states, it was a condition of their accession that they met the so-called Copenhagen criteria, which included respect for human rights, which included in practice joining the ECHR, etc., etc. So clearly that would be part of the deal for Scotland. But that's something which the independence movement seems entirely comfortable with. And what we've heard about the prospect of a Scottish constitution, for example, we haven't heard much, but we did hear something in the Scottish government's, in the independence campaign's document, or the Scottish government's document a few weeks ago, is that there is a commitment to a framework of rights within that constitution. And that framework of rights would treat the European Convention of Human Rights at least as a minimum floor of what we've had within Scotland.
My point is that, as in terms of, while the convention says how states should treat their citizens and human beings, it also, by implication, says this is how you should treat other states.
Yes, yes. Although I don't think it'd be hard pushed to say that you're in breach of any fundamental right by by playing fast and loose in terms of joining the euro. I think that might be an argument too far.
All right, gentlemen, the end of the row. Yeah.
Peter Munro. I'm not representing anyone, but what I do want to know is if the UK decide after a referendum to leave the EU, how does that affect Scotland? Would they have to accede again? Would they have to join? Would they have to have modified treaty or what?
That's a very good question. Let's think about the timetable of this for a moment. That Scotland's independence referendum is in autumn 2014. There is then a general election. Let's suppose that votes for independence. There's then a general election in spring 2015, and then the in-out referendum might occur if, let's assume David Cameron wins that election, therefore he's obliged to hold his in-out referendum. That won't happen until 2017, we're told. Meantime, Scotland would have got in by 2016. Now, all right, it's quite a complex geometry to have in your head, but can we try and struggle with that, Neil?
Yes, it's shutting the stable doors just before the horse bolts. Yes, and clearly in the, I think a lot of considerations went into the projected timetable of the Scottish government, not least getting Independence Day before the next Scottish elections. But I think another factor was clearly the possibility that European membership might become problematic from the UK perspective. Now, of course, there is always the problem of timetables slipping, and if timetables were to slip, then we could be in a difficult situation. However, it would be a very, I would have thought that under the terms of the Edinburgh Agreement, that the Edinburgh Agreement commits the British government to taking seriously the result of the referendum. And so presumably any commitment made by the Conservative Party to hold a referendum would have to be qualified by that prior commitment to honour the Edinburgh Agreement. Now, it doesn't have to be qualified by it at the moment because the timetable doesn't make it problematic. If the timetable were to slip and to make it problematic, presumably there would have to be some kind of adjustment so that there would not be a rerunning of that question before we reached the formal point of independence, because if there were, then that would, in a sense, undermine the very result of the first referendum.
Right.
So it's complicated.
Graham, it's always occurred to me that there are a number of things about the UK which irks our European partners, and one of them is the UK rebate on the budget is probably the most irritating of all the various concessions. Now, does the possibility of a UK in-out referendum in 2017, with the possibility that it may well vote for out, or does that alter the kind of thinking that there might be in Europe as to how they would treat Scotland, assuming it had voted for independence in 2014?
I think these scenarios are so complicated, they don't even want to get their brains around them. They've got other problems to deal with in the European Union. But to try to give you a more serious answer, I think it's perhaps even more complicated than you say, because in the scenario where Mr. Cameron is re-elected, he will then embark on a renegotiation and a repatriation of all sorts of things from Brussels to the UK. And if at that stage Scotland is on the way to becoming an independent state, the problem will arise, for whom is Mr. Cameron negotiating? And as I tried to indicate in my remarks, a situation where you Scots are ready to join the European Union, hopefully without mass exceptions, you would be perceived in an even more positive light. I'd just like to say here that I'm not so sure about this expression, good Europeans, which perhaps you used, but there are certainly bad Europeans. And one of the reasons why the other member states become irritated with the United Kingdom, it's not so much the rebate, and that's a very complicated story, which, you know, there are pros and cons. No, it's rather that Britain systematically wants to opt out of important initiatives which are part of the European construction. And even occasionally, God help us, London tries to block the others moving towards new initiatives. And this kind of exceptionalism is something which I wouldn't like to see it reflected in the Scottish approach to the European Union. Exceptionalism doesn't make you friends.
Right. I mean, you raise an interesting point that David Cameron would be negotiating or renegotiating terms of UK membership. At the same time as possibly Scotland is busy negotiating the terms of its membership in what you've described as a series of transition agreements. Does the possibility or the would the existence of these UK-EU negotiations mean that the EU has to have almost two sets of negotiations, one designed for if the UK stays in and Scottish circumstances there pertaining, and one designed for if the UK goes out and different Scottish circumstances there pertaining? Neil? Sorry.
Can I take one small part of that incredibly complicated question, which is that presumably one of the reasons why, if you look at the Scottish Government's timetable document, I mean, clearly the kind of neuralgic point of that document, the most difficult one, is the process, is the period between the yes vote and 18 months between the yes vote and Independence Day, so to speak. And there they use this term of a constitutional platform. They would need a constitutional platform which would provide them the bridge to independence, so to speak. It would give them the authority to actually be able to be up and running on Independence Day. And they actually specifically talk about the necessary authority in order to meet their international obligations, etc., on Independence Day. So clearly that dovetails with that part of the argument from an EU perspective, the common sense argument, which says that even though there wouldn't be, at that stage, an independent Scottish state to deal with, there would have to be some kind of sense of prior negotiation to get these things in place. So the idea that somehow David Cameron would have to be schizophrenic and work for the whole of the UK and also bear in mind the Scottish interests, it just seems so bizarrely unrealistic, especially when you do have this common sense alternative, which is actually anticipated in the Scottish Government's own document. I'm not saying it wouldn't be complicated, but I think there is a kind of realpolitik way around this.
Okay. Graham, would you want to?
I don't think I want to add anything to these complications.
Quite right. I think actually if we were to pursue this question, we'd need the services of a deconstructivist existentialist to work our way through it. A more practical question, perhaps, or any question indeed. Up at the back, up there, please.
Hi, my name's Stephen Gethins. I'm a former special advisor to the First Minister and also a former Brussels bureaucrat as well. If I can ask a practical question, which is what does the panel, in particular the practitioner, Mr. Avery, and Professor Panka from your research, what do you think the impact will be of Scottish independence on, say, the UK's negotiating position, given that, will it be a positive one or will it be a more negative one, given that Brussels makes decisions in terms of alliances and negotiation? I'd just be interested to see how you think that'll pan out.
Okay. Greer, I mean, I must say, I find it very hard to see how the UK rebate can survive any of these negotiations. What do you think?
Your question, I think, is about the rest of the UK and its continuing influence in the European Union. Well, I mean, with Scotland as an independent member, I would like to believe that Scotland wouldn't be unhelpful necessarily to the rest of the UK. And let's face it, after 300 years of union, London and Edinburgh share a large degree of the same political culture. So I think on many questions, the rest of the UK would find Scotland a useful partner, but not on everything.
But isn't it reasonable to think that, given that the UK rebate really annoys all the other states, and especially France, because let's not forget that the cost of the rebate is added on to what other member states pay in terms of what they pay to the EU. It's very hard to see how, either in David Cameron's renegotiation or in the reconfiguration of in the UK in the event of Scottish independence, how that rebate would survive. Graham?
Well, my experience of these kind of accession negotiations is this, that in general, the other member states, I'm so sorry, the other member states don't want the negotiations about the arrival of a new member to reopen a series of Pandora's boxes which they've successfully closed. What am I saying? That in the case of this complicated story of the budget contributions and the rebates, they have just taken, with some difficulty, a decision on the period up to and including 2020. I don't think that the negotiations on Scottish membership of the European Union would be allowed by the others to upset the basic economy that was made. Don't ask me to cite you individual figures for exactly how much Scotland would have to pay. That would be for the negotiators. But I'm quite convinced that the other member states wouldn't want to reopen this very tricky question. Not until 2020, when, as I said, an independent Scotland would have its own voice and its own say in the institutions.
Diana, do you think that an independent Scotland would be to the advantage or disadvantage of the residual UK?
Well, I guess it boils down to the issue at stake. If it's an issue where the UK and Scotland share interests, then it's actually an advantage of the UK to have independent Scotland, because if we basically remind ourselves of the decision-making changes that came into place with the Lisbon Treaty, at least from 2014 onwards, and definitely from 2017 onwards, which is a double majority rule in the Council of Ministers, which basically says, well, in order to pass a directive or regulation, it's necessary to have 55% of the member states on board at least. And those 55% of the member states need to represent 65% of the population. So if basically we have an issue on the negotiation table where Scotland and the UK are on the same side of things, then having Scotland as an independent country, as an ally, basically counts towards the first part, the 55% of the member states, because that's basically the part of the double majority principle that reflects the equality of states. and the second part reflects the quality of the people. And in that regard, it would actually be an advantage of the UK to have Scotland as an independent state, as an ally. On the other hand, if it's an issue where both countries would be on different side of the table, then obviously it is a big disadvantage, because that means depending on how the majorities are, Scotland could be the pivotal player, could be the one country that basically shifts majorities. And that would obviously be a big disadvantage. So it really boils down to the issues at stake. But I think what Graham pointed to as well is, if we are looking at, well, how likely is it that the two countries are on the same side of the table as opposed to basically being on opposite side of things? I think if there is a big overlap of legal acts in place, a big overlap in regard to popular culture, to political culture, to legal culture, then it's also very likely that on most items, the two countries are actually basically more or less on the same side. So in that sense, I guess overall it's probably an advantage rather than a disadvantage in the day-to-day negotiations, not the accession negotiations as such.
Neil?
Well, I was actually going to ask a question of Diana. I mean, how do the Czechs and Slovaks go on? Is there a residual solidarity in how they deal with things?
Well, yeah, I mean, they have very close contacts between the diplomats. Yeah. And so obviously those are natural allies.
Yeah, yeah. So I just wanted to come back quickly on the budget question, because in Peter's article, you took a different view. You know, you thought that this was a Pandora's box, that the existing member states might be all too willing to open again, because it's one which has been such a source of irritation, and if they did, it could have significant effect upon Scotland's net contribution to the European budget. And you cited the precedent of enlargement in 2004, where they had been willing to open that particular Pandora's box, even though it was in the middle of a budget cycle. I guess the counter argument to that would be, okay, with 10 states coming in, you know, you really can't pretend that it's business as usual. With one state coming in, then perhaps you can, especially if there might be other parts of the package which should be renegotiated in time. You know, there may be things that Scotland might actually want to renegotiate in its favour, in areas of fisheries or agriculture or whatever. And it may be a kind of silent quid pro quo that none of these things are renegotiated on the first day, and there's a bedding-in period. But therefore, they get the benefit of the rebate until 2020.
But is it not a box which actually has only one Pandora in it, which means which is more money for the EU to spend? Because the Scotland's budget contributions would be greater. The budget contributions of the residual UK and Scotland, if Scotland had a separate budget agreement, would be greater than the sum of the two parts at the moment.
You mean it wouldn't have complex ramifications, and therefore?
No.
Yeah, I think it would have complex ramifications, but I think I want to say two things. First of all, what countries pay into the EU budget basically depends on the size of your GDP. And that's the determinant of the UK as it is, and of the two separate states that might be in the future. Second remark, it seems to me that Scotland's joining the European Union as an independent state shouldn't cause the European Union to spend €1 more or €1 less. And this seems to me a common sense argument why you really wouldn't want to reopen this budgetary discussion.
Okay, fair enough then. It does occur to me, just in relation to this question, that the questioner might be able to help us, given that he's a former advisor to the First Minister. I mean, the point being that you asked about views concerning how Scotland and the rest of the UK would work, and to some observers it may look as though the Scottish Government spends all its time criticising and complaining about the UK Government. But actually, the subsurface reality might be a lot different, that in fact, it's mostly cooperation with only the occasional point of disagreement. I mean, how do you think it would work out?
Well, I think in fairness, the press tends to pick up on the areas of disagreement because areas of agreement don't sell newspapers, quite frankly. And I apologise to the members of the press who are spread throughout here. I think that Scotland's taken a very constructive approach to its relationship with the EU, and to be fair to the UK government, where areas in which the UK and Scotland agree, they tend to have a constructive approach. Now, I was interested by Professor Panka's argument there that Scotland would benefit, that it would be better for the UK as a whole if Scotland were independent in terms of the numbers of votes, except where it's not in Scotland's national interest. Therefore, I fail to see an area whereby Scotland doesn't benefit from that situation. But I think by and large, the Scottish Government and the UK Government cooperate together in areas where they agree and will continue to cooperate in areas where they agree. And unfortunately, sometimes people focus in on the areas of disagreement, but that's natural. Also, for those who are interested, Habemus Papam as well, a wee bit of Latin. We've got a new Pope.
Oh, well, that's an excitement. Yeah. If we can revert to more thrilling matters about a further question. Down at the front, down here. Sorry,
Brian Ivory, I'm an independent director of a number of financial services companies, but that's not in the context in which I speak. I wonder whether we could press you, Mr. Avery, a little further on the amount of time it might take to negotiate accession. And I suppose the second part of the question is one for Professor Walker, and that is, it's a three-stage process, the referendum, and then agreement with Westminster, and then agreement with Brussels. If we, by Independence Day, if the referendum goes positively for the independence movement, and if the Edinburgh Agreement is fulfilled, and by Independence Day we have negotiated with Westminster, but not with Brussels, what is the status of Scotland from early 2017? And I suppose going back, how realistic is it for accession to be achieved within 18 months of the referendum?
Right, okay, I think I followed that. Neil?
I think, okay, so in a sense is going over some of the ground we've covered already, where what we're saying is that in a normal case, you have a country starting at ground zero with no culture of membership, and you have to go through this whole process, chapter by chapter. And at the end of the day, there might be, and there often is, need for some kind of transitional arrangements, even after the point of membership. But these can be fairly residual. I don't suppose it's impossible to imagine the same happening in the Scottish context. Presumably, legally, there are two possibilities. One is that you have accession with some sort of conditional transition, some conditional arrangements for a transitional period, or you have some kind of transitional pact, which means that the rights and obligations flowing from the treaties continue to apply in the Scottish context, unless specifically not until such time as the negotiations are concluded. But I'm not sure which is more or less likely, or which is more or less likely to create all sorts of secondary problems. But there is a way of patching over without creating. One of the things that Sir David Edwards said in his comment is that the alternative is unthinkable. You know, the idea of actually having a legal no man's land, where all sorts of questions suddenly come up, where Portuguese fishermen can no longer fish in Scottish waters, where all students are treated as foreign students and paying full foreign fees in Scottish universities. There's so many unintended and unlikely and unhappy consequences that I think it would be in everyone's interest to avoid these. Well, it would be for the Portuguese fishermen.
Right. Question here. Sorry, sorry, I meant in the front, young chap in the front.
I'm Stuart Dilks, I work in financial services. I appreciate at the moment this is all theory and assumptions, but I'm not comfortable voting yes or no based on theories and assumptions. And is it likely that we'll get a definitive on this before the vote, or at least a nudge and a wink, wink, no problem, you're in? Or are we in a catch-22 where we vote first and then find out about the EU later? And I suppose that's the same for a lot of the bigger questions, but all we seem to have is theory, assumptions, and I'd like a bit more of a definitive before I actually vote.
Can we get definitive answers? That's always struck me as a big problem, you know, given that the UK government, which has to provide one set of definitive answers and has said it won't pre-negotiate, and the EU, given that it has at least sensitivities, and indeed, in fact, I think it's set down at one point that it won't even consider what might happen until it has a formal application to join the EU. And it seems to me the likelihood of firm answers is a bit remote.
Yeah, I mean, but let's two qualifications to that. One is that there is a firm answer, I think, to the question: will Scotland be allowed to join in principle? Yes. I don't see anyone saying no to that. So all the devil is very much in the detail, how long it will take and what the terms of accession will be. The second point I would make is that, you know, the future is uncertain regardless of the scenario that you look at. You know, I mean, the UK government has to be very, very careful about how it plays the uncertainty card, because this is a government which is committed to a process of repatriation of powers, followed by a referendum in 2017. So whichever horizon you look at, there is a high degree of uncertainty, and I think we just have to accept that.
Graham, would you?
No, I'd just like to say that no, you can't expect a definitive answer in advance of the referendum, but in that sense, the EU is only one of many questions where you have that situation. So I wouldn't elevate the EU as the #1 obstacle. On the contrary.
Okay, and there was a questioner behind there.
David Edward, 2 points, I think, and I'd like a comment on this. And they arise out of what's already been said. As regards the acquis, continuing acquis, do you agree that this could simply be done by a one-section statute, which said, as from the 1st of January 2017, the following acts and the following regulations shall continue in force in Scotland? And that would satisfy, subject to, you might have small amendments. That's a perfectly common thing, and it happened in Ireland. Ireland still applies UK acts, including the Bill of Rights, parts of it. So parts of UK acts have to be repealed in Ireland in order not to continue to apply. The second consideration is whether it's necessary to have ratification. In the case of Croatia, the accession treaty with Croatia required ratification, but the consequential amendments of the Treaty on European Union and the other treaty did not. That was done by the simplified procedure. So is it clear that ratification of the amendments to the treaty would be required?
Good question. Excellent questions indeed. Graham.
Well, I think that's a bit of a question for lawyers, but for me, in the sense that a minimum essential in the modifications to the treaty necessary for Scotland joining would be institutional changes for which affect each member state. I'm rather inclined to say it would require ratification. In reply to the question, how long would ratification take? My answer has always been, how long is a piece of string? I mean, you can make ratification last a hell of a long time, but if it's an uncontroversial affair, and if, as we would all hope, the arrangements for Scotland joining wouldn't have consequential effects in other areas, I think the ratification could be conducted very rapidly.
Neil?
The hardest question comes at the end. Actually, I was also puzzled over this question, and I read something by David Edwards who said he didn't think that he thought that the simplified revision procedure would not apply in this case, and. So it was a default opinion. Okay. Well, it does. It's not obvious that it would, is it? Because it talks about. I mean, what it turns on is a simplified revision procedure. It says in Article 48 shall not increase the competences conferred on the unions and the treaties. So it's not obvious that something which only requires institutional reform would do that. But of course, that presupposes that we're dealing with an amendment treaty as opposed to an accession treaty. So yes, I think the question is open.
Okay. Graham, in regard to the first question about a one statute act which just incorporates, lists all the relevant laws which would be incorporated, isn't it the case with accession that, by and large, where countries get a little bit bogged down is that parliamentarians want actually to go through these laws line by line and to seek out to maximise advantage where possible?
I think the best answer I can give to that question is this. In the common sense procedure which I've been describing, although Scotland would not be a signatory, would not be a direct party to the modifications of the treaty because it wouldn't yet be a member state, it seems to me of capital importance that the Scottish Parliament should have a voice to say, and therefore whatever techniques would be adopted for the implementation of the acquis in Scotland, they should certainly be examined by the Scottish Parliament before the moment of independence.
I think it's right that you could do it with the one line act. I don't think it's not going to be the interests of the Scottish political class, insofar as the Scottish political class is still wants independence, that they've to make this a difficult process. Presumably, in the first instance, they'd want this to be an easy process, but it might be something which could be revisited in due course. And part of that revisiting might also involve continuing negotiation of its relationship with the rest of the UK, which leads me on to the point that it's often quoted in this, that in the case of the Czechoslovakia, that the negotiations continued for 7 years after independence, and treaties were still being signed for that, as if that's a reason against independence. But presumably you can turn that argument on its head and say that what that shows is that it is possible to achieve the in-principle agreement, even though there are still certain detailed agreements to be put in place. And that's not necessarily the key question, but it's related to it, because some of the questions about whether and to what extent UK statute should simply be replicated in the Scottish context might turn upon, continuing negotiations between Scotland and the rest of the UK, which may not all be resolved in Independence Day.
Okay, and one of the key complaints about the EU, which is unfairly directed at the EU, is that EU law has to be passed into national law, and it's very often seems to be the case in Britain that the passage of that EU law into national law becomes gold-plated and excessively burdensome, which is a complaint that you get from the business lobby in particular. So might there not be actually a huge amount of pressure from various lobbies which we feel heavily overburdened now's our chance to get out from underneath this burden and persuade our Scottish political class to rewrite this law so that it becomes a lot simpler and less burdensome.
Well, just a point of detail, not all EU law has to be. Some forms of EU law are directly effective without requiring national implementation. Yes, I mean, I don't have a crystal ball. I mean, presumably that would be part of the argument. But it is such, going back to Pandora's boxes, you know, if the alternative, if you don't have a one-line statute, is so starkly different. You know, that if everything is opened up, you know, there'll have to be some idea that there is a formal process of consolidation and transfer, and then substantive questions can be opened up at some other point. And that may depend upon new procedures of the new Scottish Parliament as well. You know, it becomes very, very complicated, but clearly some sort of wall has to be drawn between the formality of transposition on the one hand and wanting to open up some of these substantive issues on the other.
Okay. And lady on this side here. So.
Anne Packard. Very little has been said about the potentially adverse effects on Scottish industry and commerce with the delays and uncertainties. And I feel very sorry for those who are responsible for large measures of employment, given the uncertainty. Would the panel comment, please?
Uncertainty. Well, uncertainty is in itself uncertain. Actually, I mean, so far we haven't seen an awful lot of real uncertainty. We've seen one or two companies talking about it, notably SSE. We have seen some sign that large property sales may have been affected because foreign buyers are a bit worried about the process of independence. It may or may not be something which actually happens. If you look at Quebec, when it held a referendum on sovereignty, as they called it, independence in 1995, uncertainty only really kicked in when opinion polls began to suggest that there could be a yes vote, essentially. Up until that point, when rejection was assumed, there wasn't a huge amount of effect. There was a certain amount of effect. The evidence suggests that house sales slowed and that business investment slowed. But it was a slowdown. It didn't come to a complete halt. And actually, there was a very rapid catch-up thereafter. But you know, as I say, it tends to be regulated by the opinion polls, which at the moment are suggesting that the vote's going to be no. If they start drifting towards a yes vote, then you might find that the uncertainty effects start to become a bit higher. There was another questioner who will, I think, have to be the last one, chat down at this side here.
Hello, I'm Gordon Aikman from the Better Together campaign. Just a couple of points. I think it's important to point out that the sort of process by which a hypothetical independent Scotland would join the EU is subject to huge debate. The UK government commissioned Professor Crawford and Boyle, who very much said it would be a full accession process, which is obviously far more complicated and lengthy. But if we park that for a moment and accept an independent Scotland would be able to join Europe at some point in the future by some process, I think the issue about opt-outs and the position of other EU member states is very, very important. How realistic is the Deputy First Minister's comments that she would be able to, or an independent Scotland would be able to negotiate all of the current opt-outs, so Schengen, the Euro, and as has been pointed out, the opt-out on the rebate, how realistic, given their sort of heroic timetable that they've set out, how realistic is that? And a second question for Professor Pankey. Currently, as part of the United Kingdom, we have 29 votes in the EU. What's the likely number of votes an independent Scotland would have in the EU? Because my understanding is countries of a similar size to Scotland, just over 5 million people, it's around 7 votes. I don't know if you want to make a comment on that.
Okay, well, I can just start with the last question. Well, the Lisbon Treaty basically changed the voting mechanism in the Council of Ministers. So from 2014 onwards, it's optional. From 2017 onwards, it's basically set in stone, if I'm not mistaken, that basically for each vote, there's two rounds of counting around the table. On the first round, one basically just counts the number of member states, and each and every state, regardless how big or small it is, basically counts the same. So what you need is 55% of the states sitting around the table agreeing to a particular law. If that threshold is reached, then the question is, well, do those 55% of the states that support a particular directive or regulation represent 65% of the population? So in that sense, it's no longer basically the old system of a definite number of votes that each and every state gets, but it's still a compromise between the equality of states principle and the democratic one. Well, that would be kind of the international legal one state, one vote principle, and compromised with the democratic principle with one citizen, one vote. So it's still a compromise of that particular principle, but made easier in the sense that you basically have 2 counts for each and every vote.
Okay, all right. So one way Scotland could increase its influence is by encouraging a vast amount of immigration. Anyway, the earlier question.
Yeah, I mean, just on Professor Boyle's and Professor Crawford's expert opinion, let's just be clear what it said. You know, it said yes. You know that this would have to be a formal accession process rather than a treaty amendment, and they have good grounds for that. I'm not saying they're necessarily right, but it's a good argument. But that it doesn't follow from that they think, and they don't say this, that formal accession process would be of the same magnitude, the same length, the same complexity as it was for, say, the Central and Eastern European states, for all the reasons that Graham already gave. So the distinction is not insignificant between accession and amendment, of course, but it's not as significant as it would be if you were starting from scratch. Having said that, you know, I don't think anyone can underestimate how difficult it will be to renegotiate all of these issues. You know, I think increasingly that's becoming obvious in the debate. Whereas 6 months ago, I think some people still did think that. I think people realise now that either in the short or in the longer term, questions such as justice and home affairs in Schengen, certainly the currency and certainly the budget, are going to be difficult issues. And there's absolutely no reason, you know, why the rest of Europe should roll over and do everything that the Scottish Government wants.
Okay. At that point, we have to bring things to a close, and I'm going to ask Michael Keating, Professor of Politics at Aberdeen University, and the organiser of this seminar, to make some concluding remarks.
Well, thanks, Peter. We didn't expect to come to any definitive answers here. That's not what it's about, but I think we made a certain amount of progress in our discussions. There was a certain degree of consensus amongst the panellists and the requisite amount of disagreement to make an interesting discussion. I got a new legal concept from Neil, false legal certainty. It's a nice one. I shall use it the next time I have an argument with a lawyer. We've been debating, over the months we've been talking about this, whether this is fundamentally a legal question or a political question, and come to the conclusion that it's a bit of both, but I think the panellists have very usefully clarified where law kicks in, where politics kicks in. Law is the servant of politics, of course, but legal procedures do matter. I was very struck listening to this by the comparison with the Canadian Quebec case that Peter mentioned just now, and when the federal government of Canada asked the Supreme Court of Canada does Quebec have the right to secede unilaterally under the Canadian Constitution, which was a very stupid question because everybody knows it doesn't, it came up with a very intelligent answer. He says, that's not the right question. Let's shift the question, interpret the fundaments of the Constitution, not just the black letter law, but what is the Constitution supposed to be doing here, and get back to questions of law and democracy, constitutionalism and procedure, and then imposing the duty to cooperate, which is intrinsic in the Constitution, although conflict is also possible about the Constitution, and coming towards creative solutions, as Graham was saying there. And I think the panelists have very usefully navigated their way through, showing how creative solutions may be possible, consistent with European law, but recognizing fundamentally this is a matter of political negotiation, and political negotiations are always difficult, and the negotiations precisely because people don't agree in advance about what they want to get. Listening to Diana, I was struck by the way in which a lot of what she says applies to the existing dispensation for Scotland as a devolved entity within Europe, and the complexity of trying to negotiate within multi-level systems. So even if Scotland doesn't vote for independence, a lot of what you've said, I think, will continue to be relevant. So thank you, Peter, for chairing this and for guiding the discussion. Thank you to the panelists. Thank you above all to the audience. We hope that you will come back to our future debates over the next few months, and we promise you that we will get a bigger room, because I'm sure that you'll all be back to continue our discussions to the end of the year.